In January 1998, Michael Steele and Jack Williams were convicted of the murders of Patrick Tate, Tony Tucker and Craig Rolfe, who were all found murdered in a Range Rover in Omitted, Essex in December 1995. This set of videos summarise the background to the case and the evidence and arguments put forward by the prosecution and defence at trial. For the most part, it has been taken from the CCRC's previous statement of reasons on the referral of Jack Williams' conviction to the Court of Appeal. The applicants submit, relying on the expert report of David Bristow, dated June 2007 and revised in October 2007, that the trial jury was misled on the issue of whether or not the victims answered any incoming calls to their mobile telephones after the critical 1859 call between Jack Williams and Darren Nichols on the 6th of December. It is further submitted that the Court of Appeal erred on this subject when it was considered in February 2006. At paragraph 10 of its 2006 judgment, the Court of Appeal stated the case for the prosecution was that the murders took place between 1848 and 1859 and that the telephone evidence supported this. It is a fact that the mobile phones of the deceased men did not make or receive effective calls after that time. David Bristow has argued that it would have been more accurate to state there was no sound evidence put before the court that the deceased men did or did not make or receive any calls after that time. In relation to Tucker's phone 327, Mr. Bristow states that the jury should have been informed that both the itemised billing and the Vodafone toll ticket beacon data only registered calls which Tucker could be charged for, i.e. outgoing calls and incoming calls which were passed to his voicemail. By way of illustration, Mr. Bristow points out that calls from 01268 558 162, which Mr. Tucker answered at 12:21 and 14:02 on the 6th of December, did not appear in the Vodafone toll ticket beacon data for his phone. Mr. Bristow contends Vodafone would have no record of incoming calls to Tucker's phone which were not passed to his voicemail. He adds that this leaves open the possibility that Tucker answered incoming calls after 1900 hours on the 6th of December. The Commission has considered this submission and takes the following view. Even if it was correct that the available records do not rule out the possibility of post-1900 hours incoming calls which were answered by Tucker, there remains no positive evidence that he did in fact answer such calls. In the absence of evidence on the point, it is difficult to see how this submission could give rise to a real possibility that the Court of Appeal would overturn these convictions. In addition, the Commission observes there was no other evidence which suggested that it was highly unlikely that Tucker answered his phone after 1900 hours on the 6th of December, namely the 26 unanswered messages on Tucker's voicemail, a number of those messages expressing extreme concern about Tucker's well-being.
For God's sake, Tone, phone me!
It appears to be accepted that incoming calls to the mobile phone 923, which were answered by Tate, would have appeared in the beacon data for that phone. However, the applicants make a different submission in relation to mobile phone 923. It is alleged the only reason that the beacon data for mobile phone 93 ended at 1844 was because Essex police placed time parameters on their request, i.e. they only requested data up until 7 p.m. on the 6th of December. The Commission has been urged to obtain the original application for beacon data in relation to Tate's mobile phone 923. The Commission has sought this application but has been unable to locate it within the files of Essex Police. The Commission asked Essex Police to comment upon this issue and was provided with the following written response on the 29th of July 2010. Although there is evidence within the case papers that cell site beacon evidence was obtained for the mobile telephone of Tate, no application for this data has ever been identified. This offence was committed pre-RIPA, and as such single points of contact did not exist, and there was no formatised system for such data applications. Indeed, it is my belief that Essex Police, as an organisation, had never before used this material either for evidential or intelligence purposes. At most, that telephone companies would have requested for was a data protection form, but they would very often provide this information as a result of a verbal request. Although it cannot be stated with certainty, it is possible that this material was provided after a verbal request. The Commission has considered the response of Essex Police on this issue and takes the view that it is responsible, given that there was no formal system for requesting beacon data in December 1995. Although the Commission has been unable to locate any application form in respect of beacon data from Mr. Tate's mobile phone 923, the Commission has been able to form a view of the applicant's submission that Essex Police must have placed time parameters on the beacon request. In the context of everything the Commission has seen in the course of its review, it considers to be highly unlikely that this submission is correct. The Commission notes that the beacon request in respect of Tucker's phone 327 did not include a 1700 hours time limit, and the request for billing data for phone 327 specified the period between 14:51 on the 6th of December and 8 AM on the 7th of the 12th. If Essex Police had decided to place time restrictions on requests for data in relation to the victims' phones, it seems inconceivable that they would have neglected to include the time restriction when requesting data for Tucker 327. In support of their submission regarding time restrictions on call data requests, the applicants point out that the witness statement of Barry Dorman states that he called Tate's mobile phone 923 on the morning of the 7th of December 95. It was answered by a woman. This call did not feature in the disclosed beacon data for Tate 923. The applicants submit that this shows that time parameters were placed on the beacon request. The Commission considers that even if this was true, it does not follow that a 1900 hours limit was placed on the request. A beacon request, which was in similar terms to the one made for Tucker's 327 until 8 AM on the 7th of December, an entirely reasonable limit, given that this was when the victims' bodies were discovered, which would also result in data which omitted the Barry Dorman call, and which omitted reference to calls which Tate 923 was later found to have been received on the 8th, 14th and the 18th, 1995. In further support of their submission regarding time restrictions on call data requests, the applicants seek to rely upon the witness statement David Udell of Orange plc, dated the 7th of August 1997. Mr. Udell states on the 23rd of July 1997 he received a request from Essex Police under Section 28 of the Data Protection Act 1984 in relation to Mr. Tate's mobile 923. The request was for call data from 10:19 to 18:44 hours on the 6th of December. The Commission has considered Mr. Yiddle's statement, but takes the view that the approach by Essex Police, which he describes, is likely to relate only to their efforts to place existing call data for Tate 923 in an evidential format which could be relied upon at trial, i.e. presented by an employee of the telecommunications company who provided the data. The Commission understands that Mr. Yiddle would have been able to draw on previously retrieved and saved data rather than having to conduct a new search of Orange systems. Consequently, the Commission does not consider that Mr. Yiddle's statement assists in determining whether or not Essex Police included time parameters in the December 1995 request for beacon data in relation to Tate's mobile 923. In further support of their submission regarding time restrictions on call data requests, the applicants seek to rely upon 3 pages of a document entitled Cellular Billing System in relation to mobile telephone 585 949 316. A telephone which at one stage at least had been attributed to Pat Tate. This appears to be the result of an intelligence search by Essex Police on the 12th of December 95. It purports to provide details of all outgoing calls for that phone between the 1st of November 95 and 23:59 on the 8th of December 95. And yet it lists the last call of having been made at 12:32 on the 6th of December 95. The applicants have provided the former BT telephone bill for mobile 316 in order to show that the last call on the 6th of December was actually 21:41, not 12:32. It is submitted that the cellular billing system results are evidence that Essex police were placing time perimeters on their request for data to avoid any evidence of calls having been made by the victims after 1900 hours on the 6th of December. This was at a time when police believed Tate was using mobile telephone 316 on the day in question. The Commission has considered this submission but takes the view that it cannot be correct. The former BT telephone bill for mobile phone 316, which the applicants have sent to the Commission, formed Exhibit STD1 at trial. The Commission considers that if Essex Police had placed time restrictions on their request for data regarding mobile phone 316, then they would not have requested and then exhibited the billing which formed ESD1. In any event, the fact that the cellular billing system results are stated to be for the 1st of November 95 to 23:59 on the 8th of December shows, although there appears to be missing data, the time parameters were not restricted. Having considered all the applicants' submissions in relation to time restrictions on call data requests, the Commission takes the view they do not give rise to a real possibility that the convictions would be overturned by the Court of Appeal if the cases were referred. The applicants submit that Essex Police's interrogation of the victims' mobile phone handsets was inadequate, particularly the attempts to interrogate Tucker's handset, of which DC Miller stated, "I was unable to power up the telephone due to heavy blood contamination. I was therefore unable to extract any information from the telephone." As a result of this admission, the Commission arranged for handsets attributed to Tucker, Tate, together with their associated SIM cards, to be interrogated using modern mobile telephone forensic techniques. The testing was carried out by DC James Luck, Senior Technologist at the Metropolitan Digital and Electronics Forensic Service. Dr. Luck provided his results to the Commission on the 19th of April 2010, and these were disclosed to the applicants on the 6th of May 2010. Dr. Luck's interrogation resulted in the retrieval from the memory of each of the two handsets of the telephone numbers for dialed, received and missed calls, although he could not definitely say which category of each call of the numbers fell into. Unfortunately, Dr. Luck confirmed that neither of the handsets was capable of storing the times or dates of the calls. In those circumstances, the Commission does not consider the results of Dr. Luck's interrogation are capable of assisting in the determination of whether either of the victims made or answered telephone calls after 1844 on the 6th of December. Having received Dr. Luck's results, the Commission considered the only conceivable way of making further inquiries into the dates and times for the dialed and received calls to and from the victims' mobile phones would be to analyse the itemised billing data for each of the telephone memories which were retrieved from the memory of the handsets. Consequently, the Commission has analysed itemised billing for the following telephone numbers. None of the itemised billing which had been analysed had received any post-1844 calls to either of the relative victims. The Commission has been unable to locate any itemised billing data for the following telephone numbers. Having considered all the available data and the representations of Wome, Steele and Bowen on this issue, the Commission takes the following view. There remains no evidence of any calls made or answered by any of the victims after the 1844 call. There is nothing in the applicant's submissions which is capable of giving rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The applicants have referred to the two phone calls made by Steele to Womes at 1803 and 1809 on the 6th of December 95. It is pointed out that the Crown claimed the calls were made from the car park of the Halfway House public house. However, both of the calls were served by the Childerditch Beacon, and it is said that this would not have been possible if they had been made from the Halfway House. The Commission observes that this point was analysed at trial. It is also featured in Steele's grounds of appeal for the 1999 application to the Court of Appeal and in David Bristow's expert report for the 2006 appeal to the Court of Appeal. The submission is therefore not new for the Commission's purposes and cannot form the basis of a referral to the Court of Appeal. It is submitted that Mr. Bristow's tests have now proved that it would have been impossible for Tate to receive the 1844 call from Sarah Saunders via the Wickford transmitter if he was located in or near to Workhouse Lane at that time. This submission would appear to be based upon testing which Mr. Bristow carried out prior to trial in 1997. At paragraph 4.4 of Mr. Bristow's 2007 report, he states, "More recently, I have carried out further analysis and tests on the service provided by cell identity 1404 from the Orange cell site, Wickford. However, Mr. Bristow does not give any specific details of the further analysis and tests that he has carried out, except to mention that he has carried out a study of the topograph, which shows there is no line of sight path between the Wickford cell site and any part of Workhouse Lane." The Commission does not consider that there is any new evidence on this point which was not available at the time of trial in 1997, and at this time the appeals to the Court of Appeal in 1999 and 2006. In any event, although Mr. Bristow was not able to pick up the Wickford transmitter when he carried out tests in Workhouse Lane in September 1997, the Commission does not consider that this shows it would have been impossible for Tate's phone to have picked up the Wickford transmitter in December 1995. The Commission observes that it was recognised at trial and then again before the Court of Appeal in 2006 that it was extremely difficult to replicate the exact conditions which would have existed for mobile phone usage in the area in question on the evening of the 6th of December 1995. As the Court of Appeal explained in 2006, it is exceedingly difficult to identify the variable conditions prevailing on any particular previous occasion. Thus, one cannot say whether any particular call is more likely to be routed to one cell site than another. All that can be said is whether it is possible for it to have happened. When given evidence at trial, Mr. Bristow acknowledged that variations in any of the following factors might have some effect in which beacon calls were routed through on separate occasions: erection of buildings, growth of foliage, the type of handset usage, the orientation of the handset during the call, including position within a vehicle, the presence of other motor vehicles, the prevailing weather conditions, the precise geographical position and elevation above the ground. Mr. Bristow added, "I am the first to admit that mobile phone evidence of this kind is an imprecise art." On appeal in 2006, the Court of Appeal emphasised another important variable, namely, each cell site has only so many available channels. If all the channels on the cell site are being used by other callers, then the computers will automatically switch the call to another cell site. Thus, whether a call is routed to one cell site or another will be affected by the volume of telephone traffic at this particular time. Volume and telephone traffic is particularly variable and unpredictable, but it is often at its heaviest during the evening rush hour. When giving evidence at trial, Simon Collins, a telephone expert called by the prosecution, stated, "Trying to plot where people are by mobile telephone evidence is near enough impossible. You are dealing with likelihood and possibilities, and it is very complicated." For all of these reasons, the Commission does not consider that there is a real possibility that the Court of Appeal would find it to have been impossible for Mr. Tate to have received the 1844 call via the Wickford transmitter if he was in Workhouse Lane at the time. Even if Bristow's opinion regarding the 1844 call was accepted, however, the Commission does not consider that this would advance matters significantly. Mr. Bristow's conclusion in relation to the 1844 call is, when Pat Tate received the call from Sarah Saunders at 1844, he might possibly have been in the Rettendon area, but he could not have been in Workhouse Lane, either at the beginning of the call or at the end of the call. The Commission takes the view that if Mr. Bristow was correct that Tate was in the Rettendon area rather than specifically in Workhouse Lane at the time of the 1844 call, this would not raise a real possibility that the Court of Appeal would overturn the convictions. The Commission acknowledges that Mr. Nichols' trial evidence was that Mr. Steele told him that Tate took the 1844 call when they were in the lane. But the Commission notes once again that Mr. Nichols was given a second-hand account of what he claimed to have been told by Mr. Steele, and any alleged discrepancies must be assessed in that context. The applicants seek to rely on the beacon data in respect of Worms and Nichols for the 6th of December 1995, which shows 2 short calls were made by Worms to Nichols at 18:59 on that date. The applicants submit that this reveals a discrepancy in Nichols' account of events, which is only referred to one telephone call from Worms at 18:59. The applicants add that for both calls to register on the cell site beacons, Nichols would have had to answer them by flipping open his phone each time. The Commission has considered this submission, but observes that Nichols was cross-examined at trial by Mr. Lederman QC about the number of calls which he remembered receiving from Worms. Worms has acknowledged this in the course of his communications with the Commission. This point, therefore, does not constitute new evidence or argument for the Commission's purposes. In any event, the Commission also notes that Worms, in his own trial evidence, insisted that he only made one call to Darren Nichols at 18:59. In his submissions to the Commission, Worms argues that the reason Nichols referred to one 18:59 call rather than 2 was because he was being coached in his account by his interviewing officers who were working from a telephone action pack. The action pack was drawn up from billing data, so it would have only referred to one call. The shorter of the 2 calls was too brief to have been charged by Worms' phone company. The Commission has considered this submission, but takes the view that this is pure speculation. The Commission has seen no other evidence that Nichols was coached by the officers in this part of his account. The beacon data reveals as a fact that 2 calls were made. It was open to both Worms and Nichols to give the recollection of how many calls there were, and they both did so in their evidence at trial. The Commission takes the view that this submission does not give any rise to the real possibility that the Court of Appeal would overturn the convictions if this case were referred. It is submitted that the schedules of telephone evidence, which were prepared for trial by Essex Police, were manufactured to underpin Nichols' testimony by omitting, switching, and inaccurately attributing data. The Commission has considered all of the applicant's submissions in relation to the telephone schedules, but takes the view that the points raised are not new for the Commission's purposes. When the Court of Appeal considered the applicant's renewed application for leave to appeal against conviction in January 1999, the Court stated, "In Ground 8, it is argued that the judge wrongfully omitted evidence which was inaccurate in detail and used to corroborate false claims by the prosecution. This relates in the main schedules of telephone calls, which were laid before the jury. It may very well be that there were errors in such schedules. It would indeed be surprising if there were not. It does not, however, appear, in particular, so far as the telephone calls on the day of the alleged murders are concerned, that there were errors which in any way put a false gloss on the case." Mr. Steele's submissions in relation to alleged manipulation of trial telephone schedules were also considered during the Commission's first review of his case. When the Commission referred the case to the Court of Appeal on the 15th of December 2004, it expressed the view that there was nothing to this submission beyond the argument presented to the Court of Appeal on Steele's application for leave to appeal. It is in this context that the Commission has considered Steele's numerous renewed submissions in relation to telephone schedules. The following are the Commission's responses to individual submissions. Omission of data. The applicants have pointed out that the telephone data reveals that Tate was in contact with Paul Edwards on the evening of the murders, most notably the last call made by Tate's mobile 923 on 1826 that day, and Tucker, who was in touch with Ray Sullivan and Michael Bowman on the afternoon and evening of the murders. The applicants highlight that none of the calls feature in the trial schedules of telephone evidence. It is submitted that the police withheld details of these calls from the schedules as a way of concealing all references to Edwards, Sullivan and Bowman. The Commission has considered this submission, but observes that it was made clear to the jury that the trial schedules only included calls between specified telephone numbers. For example, the schedule labelled Exhibit JWM2 only featured calls between telephone numbers listed on the laminate sheet for that exhibit, which does not include the telephones of Edwards, Sullivan or Bowman. The trial judge explained the general concept to the jury in the following terms. The main schedule, of course, does not include every call. It only includes calls to another number on the schedule of names set out in the plasticized schedule, Exhibit 249. You know that there are 31 names there. Outside calls are not included, of course, just calls between those 31 numbers. In the light of this clear direction, the Commission does not consider that it can be said that the trial jury was in any way misled about the nature of the trial schedules or the telephone calls which they included. In any event, although the Edwards, Sullivan and Bowman calls were not included in the trial schedules, the fact of those calls was disclosed to the defence since they appeared in the itemised billing and beacon data for the victims' phones. It was open to the defence to prepare their own telephone schedules which emphasised the Edwards, Sullivan and Bowman calls, if the defence wished to do so. The Commission does not consider that this submission regarding the Edwards, Sullivan and Bowman calls gives rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The applicants also submit that the trial schedules omitted reference to a call made by Mobile 316 to the landline number, the family home of Liz Fletcher, a girlfriend of Pat Tate, at 2141 on the 6th of December 1995. The applicants state that the fact of this call did not become known to them until a detailed schedule of calls entitled All Phone Calls for the 6th of December 1995, dated the 15th of January 1996, was disclosed to them prior to the 2006 appeal to the Court of Appeal. The applicants submit that the 2141 call shows that Pat Tate was alive and making telephone calls well after 7 p.m. on the 6th of December 1995, and this severely damages Nichols's version of events. The Commission has considered this submission, but observes once again that the reason that the 2141 call does not appear in the trial schedule, JMW2, is because the schedule only contained calls between the specified telephones listed on the laminated sheet for that exhibit and is not included on that sheet. However, the itemised billing for Mobile 316 was exhibited at trial, so the fact of the 2141 call was disclosed to the defence. The applicants suggest that notwithstanding the disclosure of the 2141 call via Exhibit ESD1, the Crown's decision not to include this call in the trial schedule was a deliberate attempt to mislead the jury and to distract attention from a call made by one of the victims well after the time of the murders, as alleged by Darren Nichols. The Commission does not consider this to be correct. There is no evidence that Mr. Tate had Mobile 316 in his possession on the evening of the 6th of December 95. The only telephone discovered on his person on the 7th of December 95 was the one which became Exhibit PSB 43 at trial, referred to as the Mobile 923. This being the case, there would have been a greater danger of misleading the jury if the 2141 call had been included in the trial schedule. The Commission considers that the available evidence actually points towards Liz Fletcher having had Mobile 316 in her possession on the 6th of December 95. Police message M165, dated on the 8th of December 1995, details a message from Anne-Marie Whitehead, Tucker's girlfriend, that Tate's old mobile is in the possession of a female called Liz Fletcher. DC Winston's report, R8A, dated 11th of December 1995, describes attending Tate's home address with Sarah Saunders on the 9th of December 95, when Miss Fletcher arrived and returned the front door keys to the premises, keys to the Mercedes car, and Miss Saunders' mobile phone. The Commission notes that the telephone bill for Mobile 316 was in Sarah Saunders' name. In a police interview on the 13th of June 1996, Sarah Saunders describes the same occasion when in company with Essex police, she met Liz Fletcher at Tate's address, and Miss Fletcher returned the mobile phone, which was registered in her, Miss Saunders' name. The calls for mobile 316 on the 6th of December 1995, which appear in Trial Exhibit ESD1 and is scheduled entitled All Phone Calls for the 6th of December 95, are at least as likely to have been made by Liz Fletcher as by Tate. The Commission notes that the telephone number, which was Miss Fletcher's home number, was called twice by mobile 316 on the 6th of December 1995. This could well indicate Miss Fletcher telephoned in her home. In this connection, the Commission also observes that mobile 316 proceeded to call the Fletcher home on the 7th and 8th of December 1995, after Tate's body had been discovered. The Commission notes that Steele's submission that the calls from mobile 316 on the 6th of December 1995 are likely to have been calls from Tate to Liz Fletcher, which are described in Fletcher's witness statement. However, the Commission does not consider this to be correct. All of the calls from Tate, which Fletcher describes in her statement, can be accounted for using the billing for Tate's landline and the billing for his mobile phone 923. In light of those points, the Commission considers that it is entirely reasonable for the 2141 call from the mobile 316 not to be included in the trial schedule of telephone calls. The Commission does not consider that the applicant's submission on this matter give rise to a real possibility that the Court of Appeal would overturn the convictions if the case were referred. A further alleged omission from the trial telephone schedule is the call from Craig Rolfe's mobile telephone 0378 307 404 to an unknown telephone number 0374 722 850, made at 11:09 am on the 6th of December 1995. Once again, the reason that this 11:09 call does not appear in the telephone schedule JWM2 is because the schedule will only contain calls between the specified telephone listings on the laminate sheet for that exhibit. 0374 722 850 was not one of those telephones. In any event, the Commission considers that calls from mobile telephone 0378 307 404 on the 6th of December 1995 are irrelevant, as there is no evidence that this telephone was in Rolfe's possession on that day. Further alleged omissions from the trial telephone schedule include a call from Steele to the Great Bentley Park telephone kiosk on the 11th of November 1995 at 10:06 am and a call from the Halfway House telephone kiosk to Tate on the 5th of December 1995 at 17:03. In both of these instances, the Commission understands that these calls were not included in the trial schedule because the number of the kiosks in question were not included on the laminate sheet for exhibit GMW2. The same is true for calls which were made from Tate's landline to the landline of Claire Kerry, one of his girlfriends, at 17:15 and 18:06 on the 6th of December 1995. In all instances, the fact of these calls was revealed to the defence in that the relevant billing was disclosed. The applicants further submit that the trial telephone schedule omitted references to the call from Nichols to Steele on the 5th of November 1995 at 20:46 and from Nichols to Steele on the 6th of November 1995 at 16:36. The Commission notes that these omissions were raised by Steele at trial and were agreed by the Crown. The Commission also notes in relation to the 6th of November 1995 call that Prosecution Counsel directed Steele to the telephone schedule, which does include the call in question. The Commission does not consider that there is any new evidence in relation to these omitted calls which could give rise to a real possibility that the Court of Appeal would overturn the convictions. It is pointed out that Steele's call to the BT payphone of Bedloes Avenue, Raywith at 11:53 on the 11th of November 1995 was in the correct position within an unused trial telephone schedule, but incorrectly appears as the last call of the day in the trial schedule. It is submitted that this difference between the schedules shows that Essex Police manipulated the data in an attempt to mislead the jury. The Commission observes that this point was raised by Steele in his trial evidence, but it was accepted by the Crown that the call appeared in the wrong place in the trial schedule. The Commission also observes that in his application for leave to appeal in 1998, Steele made the submission that this inaccurately revealed police misconduct and was aimed at deceiving the trial jury. The submission was considered by the Court of Appeal in January 1999, and so this is not new for the Commission's purposes. The same is true of Steele's submission regarding the reversed order of 2 calls timed at 20:39 on the 6th of December 95, one from Steele's landline to Steele's mobile, and the other from his landline to Wome's mobile. Steele's submission that the reversal of these calls in the trial schedule was a deliberate attempt by the Crown to undermine his alibi was before the Court of Appeal in January 1999. The Commission does not consider there is any new evidence in relation to the switching of data which should give rise to a real possibility that the Court of Appeal would overturn the convictions. The applicants submit that Essex Police, or the CPS, misled the jury by listing in the trial telephone schedules that the Saunders Tate landline was solely used by Pat Tate and that the Street Steele landline was solely used by Michael Steele. It is submitted that Miss Saunders and Miss Street were good friends who used to talk on the phone frequently, but the jury was left with the false impression that all the calls between the 2 numbers were between Mr. Tate and Mr. Steele. The Commission observes that this point was raised by Steele in his trial evidence, and so the jury were well aware of it. The Commission also notes that the point featured in Ground 8 of the Grounds of Appeal drafted by Steele in June 1998 and considered by the Court of Appeal in January 1999. It is therefore not new for the Commission's purposes and cannot form the basis of a referral to the Court of Appeal in the absence of exceptional circumstances. The applicants further submit that Essex Police and or the CPS wrongly attributed mobile telephones to Craig Rolfe. It is pointed out that these 2 telephones were actually registered to Rolfe's brother Michael and to Penelope Hughes, Michael Rolfe's partner. In relation to 0973 344 913, the applicants will be aware that although this was registered to Michael Rolfe, there was evidence that Craig Rolfe was a user of the phone for a considerable period of time. According to Penelope Hughes' witness statement, dated the 9th of April 1997, Michael Rolfe had obtained the phone for Craig due to the latter's poor credit rating. Craig Rolfe had used it for 13 months, but then had lost it a matter of days before he was murdered. Craig Rolfe's partner, Donna Jaggers, also confirmed that he had lost his telephone a few days before he was murdered. Throughout its review of this case, the Commission has discovered no evidence to suggest that Craig Rolfe was still in possession of mobile phone 0973 344 913 on the 6th of December 95. Nor has the Commission discovered any evidence of calls to or from this number after 1700 hours on the 6th of December 95. In relation to 0378 307 404, the Commission observes that Penelope Hughes, in her April 1997 witness statement, stated that she was the sole user of this telephone. The applicants submit that this phone was wrongly described as Rolfe's mobile in the trial telephone schedules, as evidenced by the call made at 12:04 on the 7th of December 1995, after the bodies of the victims had been discovered. Whilst the Commission acknowledges that this call was incorrectly attributed to Rolfe, and the same may be true of other calls in the trial schedule, it does not consider that this point in itself gives rise to a real possibility that the Court of Appeal would overturn the convictions in this case. In support of his allegations regarding manipulation of the trial telephone schedules, Steele has provided the Commission with an expert report by Ross Patel. The report concludes that anomalies in the telephone schedule cannot be explained as computer errors, but can only be attributed to manual revision on the part of the computer operator. The Commission has considered Mr. Patel's report and makes the following observations. Mr. Patel does not discuss any anomalies in the trial telephone schedule which have not already been addressed in Steele's own representations. Patel does not provide any expert analysis in relation to calls which were omitted from the trial telephone schedules. He merely repeats Steele's own submission that there are calls in the unused schedules which do not appear in the trial schedule. Patel's expert comment solely applies to the sequencing of calls. None of the points raised by Mr. Patel is capable of assisting the Commission or the Court of Appeal on the subject of the time of death. Mr. Patel's points appear to relate solely to the applicant's allegation that the Essex police manipulated trial evidence. Having considered Mr. Patel's report, the Commission takes the view that it does not significantly add to Steele's submissions regarding omissions, ordering, attribution of telephone calls as considered by the Court of Appeal in January 1999. As the Court of Appeal acknowledged at that stage, it was not surprising that human error had occurred in the compilation of the schedules. The Commission notes, in this connection, the complexity of the telephone evidence and the fact that this was one of the first prosecutions to feature such a large volume of telephone data. The Commission does not consider that Mr. Patel's report provides any additional support for the allegation that Essex police manipulated the trial telephone schedule in an effort to mislead the trial jury. In the absence of any evidence of bad faith on the part of Essex police or the Crown in relation to the trial schedules, the Commission does not consider there is a real possibility that the Court of Appeal would find there to have been an abuse of process in this case. Having considered all the submissions in relation to the telephone schedules, the Commission takes the view, even if one or more of the submissions on the subject were new, the Commission does not consider that any of these submissions are capable of affecting the key issues in the case, namely, the time that the deaths occurred, and the question of whether Mr. Nichols told the truth in the essential aspects of his account. The Commission considered that this was essentially what the Court of Appeal was referring to in 1999, when it stated, "It does not however appear, in particular so far as the telephone calls on the day of the alleged murders are concerned, that there were errors which in any way put a false gloss on the case." The applicants submit that the Court of Appeal was wrong to state, in February 2006, that cell site evidence provided compelling evidence for Nichols' version of events, as Nichols did not and could not have known about the cell site data when he gave his account to police. The Commission has considered this submission and has discovered no evidence which suggests that Essex police revealed cell site data to Nichols before he gave his account. Whilst it is clear that Nichols was asked questions about itemized billing in police interview at 16:38 and 17:20 on the 17th of May 1996, the Commission has seen no evidence that police revealed cell site data to him. The Crown disclosed at trial that Nichols' interviewing officers had worked from an action pack, which was in the form of a call schedule drawn up from itemized billing, but there was no suggestion that this included cell site data. The Commission notes that Nichols was cross-examined at trial about the nature of the telephone data that it was shown in police interview. In making their submission about Nichols' knowledge of cell site data, the applicants seek to rely upon David Bristow's expert report of June and October 2007, where Mr. Bristow points out that Essex police obtained the relevant cell site data almost 5 months before Nichols was interviewed. The Commission acknowledges that this appears to be correct, but it does not follow from it that the data was shown to Nichols before he gave his account. In further support of the submission regarding Nichols' knowledge of cell site data, Womes and Steele's legal representative, Mr. Bowen, relies upon the transcript of the Section 19 inquiry interview with DC Winston, which took place on the 30th of March 2004. At page 31 of the transcript of the first interview, the following exchange took place.
Did you at any time coach Nichols so that his evidence matched the cell site analysis that you were aware of?
No, definitely not.
Was he ever made aware of the results of the cell site evidence that you were aware of?
Well, I don't know, sir. I don't believe I've made him aware.
Was the knowledge of the cell site analysis part of your interview then?
Yes. It could have been at some point, yeah.
The Commission has considered these responses by DC Winston in the context of his earlier answers in the interview.
When you started these interviews, when Nichols started to speak about the murders, in terms of locations, all the things that happened, can you remember what your depth of knowledge was as a previous member of the investigation team regarding the in-depth matters of these investigations? And a good example is cell site analysis and that type of thing. Or when Nichols started to speak to you, was it effectively fresh to you? It's giving you locations and the route in and out and everything. Was that completely new to you?
Yes. To the best of my knowledge, it was completely fresh to me at that stage.
Right. Bearing in mind that you would have had briefings fairly regularly. Things like cell site analysis is the best example I can think of. Would you have known the in-depth detail of what was going on elsewhere in the investigation?
We may have had an overview, but the cell site analysis, I'm not sure that I knew all the details, which I could recall now. That was done by a specific set of people, and I don't recall being specifically told the results of all the analysis. I don't recall the specific details of the cell site analysis on specific claims.
The Commission notes that DC Winston was cross-examined at trial about the use of telephone data when interviewing Nichols.
When you was interviewing Mr. Nichols, did you have in front of you and available for him to look at various documents?
On some occasions, I believe.
So let me give you some examples. Did you have telephone toll tickets? In other words, the record of calls made between the various people in the case?
Yes, sir.
You see, were you in fact using document toll tickets to assist Mr. Nichols in getting a cohesive story together?
The only reason documents were used was to prove or disprove what Nichols was telling us.
The Commission also notes that DC Brown, the police officer who interviewed Nichols alongside DC Winston, was questioned at trial about the telephone data which was used in the Nichols interviews. Although he acknowledged that an action pack was used which contained call data, DC Brown denied that any call data was fed to Nichols before he gave his account of events. The Commission also notes the witness statement given to the Section 19 inquiry by Lee Craddock, dated the 14th of May 2004, a solicitor who represented Nichols during many of his police interviews. At page 5 of the statement, Mr. Craddock stated,
"It was only some time later that I became aware that the police were to use cell site analysis to plot the movements of mobile telephones. At the time, I did not know that such analysis was possible, and I am certain from Darren Nichols' reactions and questions to me, neither did he."
Having considered the trial evidence of DC Winston and Brown, the witness statement of Lee Craddock, and the Section 19 interview with DC Winston, the Commission makes the following observations. Both officers have acknowledged that, as the interview process developed, they gained some awareness of inquiries that were being undertaken in relation to telephone data. Both officers have acknowledged that the telephone data formed part of the packs which were used when interviewing Nichols. There is even a suggestion in DC Winston's answer during the Section 19 interview that DC Winston gained knowledge of the cell site analysis and that this knowledge informed some of his questioning of Nichols. However, the Commission has seen no evidence which suggests that either of the interviewing officers revealed cell site data to Nichols before he gave his account on the 14th of May 1996. The Commission notes that the officers specifically denied, both at trial when asked by the Section 19 inquiry, that they had ever coached Mr. Nichols using the cell site data. Mr. Craddock has also expressed the view that Nichols was not aware at the time of his interviews that the police could plot the movements of mobile telephones using cell site data. In the absence of any evidence that Essex police revealed cell site data to Nichols before he began to give his account on the 14th of May 1996, the Commission does not consider that this submission is capable of giving rise to a real possibility that the Court of Appeal would overturn the convictions in this case. In any event, the Commission notes that DC Brown and DC Winston gave evidence before the Court of Appeal in 2006 that applicants were in possession of the Section 19 materials prior to the appeal hearing, and could have questioned the officers at that stage regarding Nichols's knowledge of the cell site data. In all of the circumstances, the Commission does not consider that this submission can form the basis of a referral to the Court of Appeal. The applicant's query why the last number dialed on Pat Tate's landline, according to the memory of the telephone handset, is said to have been Tony Tucker's mobile 327 when the last outgoing call on the 6th of December 1995, according to the itemised billing data, was to Claire Carey at 18:06. The applicants admit that the finding of Tucker's number on the handset means that Tate's landline must have called Tucker again after 18:06. They further submit that such a call is most likely to have been made after 10 p.m, as Claire Carey's account was that she stood outside Tate's house between 6:10 and 10 p.m, and Mr. Tate was not there. The Commission has considered this submission, but does not consider that there is any positive evidence of a post-18:06 call by Tate's landline to Mr. Tucker's mobile. In the absence of such evidence, the Commission does not consider that this submission gives rise to a real possibility that the Court of Appeal would overturn the convictions. The applicants submit the audio tape recording transcription of telephone mailbox messages from Tony Tucker's mobile 327 is an inaccurate transcription of the tape recorded messages for that telephone. It is pointed out in particular that the last two messages on the trial transcript were actually only one message on the tape, left at 18:13 on the 5th December 1995, and that an additional message was left at 09:57 on the 8th of December 1995, featuring background television noise, which is not listed on the trial transcript. It is submitted that these alleged inaccuracies demonstrate conscious manipulation of the mailbox transcript by Essex Police, which was deliberately aimed at deceiving the trial court. The Commission has considered this submission and takes the view that even if the applicants are correct about the inaccuracies in the transcript, this does not amount to evidence of a deliberate attempt by Essex Police to deceive the trial court, nor, in the Commission's view, are the inaccuracies capable in themselves of giving rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The applicants also make the following arguments in relation to the voicemail for Tony Tucker's mobile 327. The fact that he did not answer the incoming call at 19:09 on the 6th of December does not equate to Tony Tucker being dead and unable to answer his mobile phone, as he may have had his phone turned off, or had no network signal, or been engaged on another incoming call. The 1909 caller did not leave a message for Tucker, so he would not have received an alert from his voicemail, and this could explain why he did not return the call. In any event, searches of the relevant billing data illustrate that Tucker often failed to respond to messages left on his voicemail. The Commission has considered the applicant's submission on this issue, which could have all been raised at trial, and takes the view that they add nothing to the evidential position as set out for the jury. It remains the case there is no evidence that Tucker made or answered any calls after 17:07 on the day in question. Whilst on its own, this does not equate to Tony Tucker being dead and unable to answer his phone at 19:09. The absence of any evidence of Tucker using his mobile after 19:09 was a legitimate aspect of the case for the jury to consider. These submissions do not give rise to a real possibility that the Court of Appeal would overturn the convictions in this case.